Welcome to Appointed Counsel, a podcast presented by Tennessee Court Talk for those involved in indigent representation. I'm Joe Byrd, lead attorney for the Indigent Services team of the Tennessee Administrative Office of the Courts.
Episode 15, Overclaim Audit. Well, the podcast today is on that topic, overclaim audits. I know so many attorneys don't like to hear about an overclaim audit. I have a special guest here today from the Indigent Services team who's with me to discuss this issue, Jasper Beard. Jasper is our compliance officer on our team. Jasper, good to have you here. We're glad to have you on the podcast.
I'm glad to be here. Hello to everyone.
So they know you by emails and maybe a few phone calls, but most of the listeners, right, to this podcast are attorneys who take appointed cases. So tell us a little bit about what you do in your work for the Indigent Services team. What kinds of functions do you do? What are the things you work on?
I work on overclaims, interpreter claims, court reporter claims, and time log billing.
A lot of attorneys may not know that we actually do administrate the interpreter claims. They're not paid under Rule 13. They're paid under another rule, under the Tennessee Supreme Court rules. But the AOC has to process those claims. And so you review those claims like the other auditors review dependency neglect claims or non-capital criminal cases, right?
That's correct.
Claims. And in fact, Jasper has a job that's difficult because there's different rules that apply to interpreters on mileage and how we recently changed the in-county mileage for attorneys, but that doesn't apply for interpreters, and they have a basic amount of billing that they can do for so many hours, and that's not something that is allowed for attorneys. So you have to think kind of different ways. The other thing you said that you do is court reporters.
Yes, sir.
There are times that I guess the attorney who's appointed, they need to preserve the record, maybe of a preliminary hearing or something, or if there's a deposition and they have to hire court reporters and they get prior approvals, and when those claims come in, the invoices, is that what you're talking about that you do?
Yes, sir.
Matter of fact, we have an entire podcast that I had with Lisa Angel talking about court reporters and how to use them, because they're different than any other kind of expense under Section 5 of Rule 13. Now, most of my listeners know what I mean by Rule 13. But let's talk about this overclaim thing that you do. My understanding is some years back, the Comptroller's office did an audit, and it was before my time and yours. So this predates us, and it predates a lot of the people who are at the AOC. And it wasn't anything that anyone was doing wrong, but the Comptroller's office came in and in an audit made a finding that our system, ACAP, wasn't allowing us to track when somebody was billing a lot of hours on a day. So how did we know we weren't overbilling? And so ACAP was changed to flag claims in what we call internally, our inside baseball, is overclaim status. Tell us, what are the kinds of times that the claim is flagged as an overclaim?
Overclaims are normally flagged when an attorney bills over 8 hours in court on a given day, or when the attorney bills 12 hours total on a given day.
Okay. So like in court time, most of our listeners will know what we mean. That's time in front of the judge or arguing the case in front of the jury. And so it's over 8 hours and then 12 hours in a day. So we know attorneys who work burning the candle at both ends. They're going to work well over 12 hours. So this isn't a common thing, especially the out of court 12 hours in a day, right?
Correct.
Now, I'm assuming, though, that 8 hours of in-court time, that would be a little less regular, wouldn't it?
That's quite normal.
Over 8 hours a day or under 8 hours?
Under 8 hours a day.
Yeah, right. I mean, it would be uncommon for them to work over 8 in-court hours. You'd have to be in like some trial that ran late or something like that. Now, what I understand happens is when a claim comes in, it goes to you first before it will go down to the auditors. Is that right?
That's correct.
And I've explained to some attorneys that that's really to their advantage, because sometimes working out the overclaim, depending on how many hours it is, might take us a little bit of time, right?
That's correct.
Okay, so ACAP flags claims as an overclaim. So what's the first thing you do?
The first thing I do is send the attorney an email.
Do attorneys get the same email requesting information, the same for everybody?
That depends on the number of hours they've billed.
If it's only like an hour over the 12, or if it's an hour for 8 in-court hours, what happens then?
If it's an hour, over an hour or 8, I just ask for a sworn statement.
Okay. And by the way, a sworn statement's the same as an affidavit under the rules. So you actually send them a copy of that
I do.
affidavit. So for a lot of attorneys that I know, and I think our threshold's 3, if it's 3 hours over the limit, you only ask for a sworn statement, right?
That's correct, yes.
And basically that sworn statement's just saying, I worked these hours that I put into the system, right?
That's correct. I work these hours, and there will be more hours billed on this date, or there will be no more hours billed on this particular date.
Right. And if I'm not mistaken, you sent them a copy of this overclaim report. Is that right?
Yes, sir. I send them a copy because a lot of them, I don't know why, but they don't know how many hours they've billed on that particular day.
Well, I kind of know. I think it surprises them because ACAP has no way of tracking and going through and looking at particular days. The attorneys don't have the opportunity to run a report and see what happened. You're actually running a report for a particular day, and it might have 5, 6, 10 claims
That's
that
correct.
had hours. So for the attorney, it might sneak up on them, right? They're just they can be taking copious notes of what they're doing, and they're putting in their hours, and they have no idea that it's actually accumulated over 8 hours in that day. Now they'll know that was a long trial day, or they'll know that they were working at the office till 9 o'clock that night or whatever, but they haven't really thought through that the total hours that they put from 5 claims or 6 claims exceeded 8 in-court hours or 12 hours in a full day. So, and I have also found that sometimes attorneys don't take time to read that report that you send them. First of all, because it's just, some attorneys get frustrated, and I understand their frustration, but they just get frustrated. In fact, if they'll take a minute and just look at it, I think the majority of the overclaims are for less than 3 hours, right?
That is correct, which is just basically returning a sworn statement, and then that closes the audit.
Right. So all they have to do, they don't have to go to a notary. They just have to sign the sworn statement, fill in the information, and scan it and return it to you in an email form.
That's correct.
Yeah. And that's the majority of the overclaims.
Majority of the overclaims.
Right, now, let's go to this one, though, because here it comes. What happens when it's more than 3 hours over the limits? So say it's 12 hours in court, or it's 16 hours total in a day. Do you just want a sworn statement for them?
No, sir. I need a little bit more than that. I need the time records as proof that you've worked these hours.
Yeah, and that goes back to Rule 13 under Section 6, talking about how attorneys are going to be held to a high level of accountability to maintain the records, their contemporaneous time records. And we've done some previous podcasts on that, and that they have, if they don't give the supporting documents, if they don't give us the sufficient information to process the claim and the contemporaneous time records, that could be grounds for a denial. And we never want to deny a claim, but we have to have those contemporaneous time records when it exceeds 3 hours over the in-court or out-of-court time. And we sort of put those thresholds in. It seems to me if the majority are small overages over the thresholds of 8 in court, 12 out of court, that it's a pretty simple thing to fix for attorneys, and they shouldn't just immediately panic, right?
Right.
Or just respond to your email. Because if they don't respond to the email, what eventually happens then?
The claim could be reduced, denied.
Yeah, and sometimes we'll go through and you and I will talk, and when they haven't responded several times, I mean, we could always reactivate them if they start responding, but when they don't respond, we just have no option. We're not going to move on that claim until they respond, and it saddens me because sometimes all it takes is just fill out the form real quick, get it back to us, so that if we ever have a comptroller's audit, they can see that we've asked, we've done some due diligence on it. So, knowing that, there's a lot of these claims are for so much smaller, are there some common reasons why these overclaims get triggered like that?
Duplicate billing, wrong dates, keyed, or entry errors.
So like instead of me putting 0.6 hours down, I put 6.0 hours
That's
down.
correct,
right?
yes.
Yeah, okay. What about, I suppose there could be times when if they put a claim in that's denied and those hours count against that day, can that happen and count against them too?
Yes, that can happen.
Or maybe if maybe they removed a claim, that can also cause an overclaim that we have to look at too, right?
That can happen as well. I've seen that as well. It's more so just the dates and duplicate billing, really.
Yeah. So there's a process now when we get to these, the more in-depth claims where we're talking about needing the contemporaneous time records. And the new amendment I mentioned of Rule 13 kind of lays out this process when an audit, overclaim audit is flagged in the process. And if they go through and they'll respond to us and we say there's a reduction that needs to be made, it's not the end of it necessarily, because there is an option for them to ask the Chief Justice to review any kind of reduction if it's substantial that we think is important. But they do have to follow through what the rules say, which is that attorneys are going to be held to a high degree of care in keeping those contemporaneous time records, and that will support those claims, and also to keep all of those documents and give us a sufficient description in order to be able to support what they're doing. And I know, and my listeners have heard this before, I know it's a hassle. No one wants to keep a notebook and saying, 15 minutes did this, phone call for 7 minutes, and bill in tenths of an hour. It's very strange. It's not the normal thing. So I get their frustration, but overclaims are not the end of the day. In fact, would you agree with me that if most attorneys would just respond, overclaims can be pretty well cleared pretty quickly, the vast majority?
Majority of them are cleared pretty quickly. You may have a handful that I never hear back from months on end, and but more so, I usually hear from attorneys within the day that I send the email.
So, and do they send the sworn statement most of the time? And
they send it right back that same day.
Yeah, and then you close the audit,
close it up,
move on with life, right?
Yes, sir.
So, and then the payment gets reviewed, through the normal process. It doesn't get sent over to finance and administration after you're clearing that audit. It still has to go through the review process. Well, Jasper, I'm going to just say, I really appreciate the work you do here. I know that you're actually doing a little bit of training, I think, going to get your certification, aren't you?
Yes, sir. This in the process to become a certified fraud examiner.
Yeah, I think that's going to maybe serve us well. I think a lot of folks who work over in the comptroller's office have that certification, and it will help you in your work here, but will also, our hope is it's going to help you be a communication whenever we need to talk to the comptroller's office.
That's correct.
You'll understand their lingo a little better than me as the attorney. What about it? Are there some suggestions that you would give to attorneys just generally when it comes to overclaim audits?
The main point I would like to convey would be just to respond to the email that I send. I mean, help me help you. That's all I want to. That's all I'm trying to do is just to help you to get paid.
Right.
So
you're not against them getting paid.
I'm not against them. I'm trying to help you get paid. So just respond to the emails that I send with the documentation that I'm requesting, and then we can make this process as painless as possible. Another thing I would like to tell the attorney is to keep their contemporaneous time records. That is very important when it comes time to audit some of these claims that I'm processing.
Yeah, it's a pain in the neck for attorneys, right? And we understand that. It's a frustration. But if they don't do it, right, they put us in a box,
right,
I think, in terms of it. Well, Jasper, it's been great. We're demystifying what are overclaim audits and sort of making sure that everybody understands it's not the horrible experience for the most part for the vast majority of claims. And appreciate you taking the time today.
Enjoyed it.
For more information, check out the Indigent Representation webpage at tncourts.gov.